Okay, welcome to the first of some review videos for week 14 review week. I'm going to talk about how to how you know that you're being tested on substantive due process. Obviously, if the call to question asks you to address substantive due process, then you know you're being tested on substantive due process, right? So sometimes the call to question will give it away. If the call to question just asks you for a constitutional violation, right, whether there is a constitutional violation or something like that, so it's a very broad, ill-defined call to question, then how do you know you're being tested on substantive due process? Here are what you might call the elements of a fact pattern, right? We're not talking here about the elements of a law, but the elements you're looking for in a fact pattern that would cue you, right, that you are being tested on substantive due process. The first thing you want to look for is an individual, right? Individual, a group of individuals, right? Because substantive due process rights do not belong to corporations. They do not belong to associations or entities like that, right? They belong to people as individuals. Remember that, and that certainly makes sense because we're talking here about privacy types of rights, right? So Exxon doesn't have privacy interests. So, first of all, substantive due process applies to individual rights. Usually, in relation to what I just said, usually what the individual is asking for is some kind of right that involves, right, bodily integrity or the integrity of the home or the person's own space or the person's own decisions, the person's control over his or her own life. So first of all, you look for the individual. Second, there has to be some claim by whoever's challenging the government of a right to do something, right? I think we beat this horse to death, right? The substantive due process is not a groups-based or classification-based claim, it is a rights-based claim, right? So I have to be as an individual, or, obviously you can have, the ACLU or something like that suing on behalf of individuals, right? But you have to see individuals, and you have to see them asking for the right to do something. And as I mentioned a second ago, usually that something has to do with personal privacy, personal space. And finally, and very importantly, whatever right it is that the individual is asking for, if you're doing a substantive due process analysis on an exam, right, that had better not be a right that's already listed in the Bill of Rights. So you have to be familiar with the Bill of Rights, right, Amendments 1 through 10. Okay, the Bill of Rights is Amendments 1 through 10. Amendments 1 through 8 really enumerate rights, right? They really create a list of rights. The 9th and 10th Amendment are relevant to all of that, but you'll see the rights actually identified, right, in 1 through 8. Now, most of the time in constitutional law coursework, right, if you're being tested on the Bill of Rights, it's usually the First Amendment, right? Freedom of speech, freedom of religion, press, assembly, association, all that. So, in other words, what I'm telling you is, if you have a speech issue or a religion issue, right, on an exam, and you start doing a substantive due process analysis, right, for the right to speak or the right to practice your religion, you are way off base. So, again, you need to have an individual or group of individuals, right, claiming some kind of right. Typically, it has to do with privacy or space, right, personal space, and that the right, however you define it, has to be something that is not listed in the Bill of Rights. So one more time, that does require you to be familiar with, right, what is in the Bill of Rights. Of course, to pass a constitutional law exam, or for that matter, a criminal procedure exam, right, which is basically another type of constitutional law, you should be familiar with the entire U.S. Constitution. That is not to say memorize it, but you've got to be familiar with what's in there, or you wouldn't be able to do that analysis, right? If you don't know what rights are enumerated, right, are listed in the Bill of Rights, then again, that can be a problem. That could lead you to do a substantive due process analysis where you should be doing a straight up fundamental rights analysis, right? An enumerated rights analysis instead of an unenumerated rights analysis. So there again, one of the fundamental things that we all have to get our heads around is the difference between listed and not listed, right? Between enumerated and unenumerated rights. Now, that's sort of issue spotting on a macro level. certainly for an essay, right? If I'm asking you to determine whether a court should recognize some new individual right, one that's not listed in the Bill of Rights, but nonetheless individuals are asking courts to recognize it as some kind of a fundamental right. Now, if you're talking short answers or multiple choice types of questions, right, then you look out for the rights that the court has already said these are unenumerated fundamental rights under substantive due process, right? That includes what procreation, marriage, marital privacy, family living arrangements, the unitary family, care, custody, and control, right, of your children, assuming you're a competent adult, and one kind of this is a little bit nuanced, but the right to refuse unwanted medical treatment. I think most professors, and I'm with this group, treat that as a fundamental right under substantive due process. The only reason there's any issue with that, and I don't want my students even to worry about this, but is that in Cruzan, the court treated the right to refuse unwanted medical treatment as a fundamental right without actually expressly stating that it's a fundamental right. But I think most professors agree that it should be treated as a fundamental right under substantive due process. Though when you see questions about those things, right, those are issues where the court's already decided that that's a fundamental right. There you would go straight to strict scrutiny, right, and look for whether the means are narrowly tailored to the achievement of a compelling interest. One more thing about issue spotting, obviously abortion issues are very easy to spot. You have to take the oath that you would never apply strict scrutiny in an abortion case, right? Abortion cases are to be handled under sort of this trio of cases, right? Roe, which was modified by Casey, right, which was again tweaked in Hellerstedt. So the rules for abortion, right, post-viability, the government can ban abortion procedures with an exception for the health of the mother. Pre-viability restrictions have to go through the Hellerstedt balancing test. Okay, I'll have more on substantive due process in another venue, but I did want to at least do an issue spotting. A video that how do you know you're being tested on substantive due process? You have individual or individuals claiming, right, a right to do something, right? Not that they're being picked on because of the group they're in, but they're claiming a right to do something, and whatever they're claiming a right to do was not listed in the Bill of Rights. We'll be back for more later on. Be well and stay tuned in.